Welcome all to the post-lunch sessions. May I request the chair and the other panelists to please come onto the stage. The theme for this session is emergency arbitration and its developing contours in India. Emergency arbitration is a common remedy available under various institutional arbitration rules and give the aggrieved party an effective, speedy, and additional remedy to approach the arbitral institution. In this session, in a post-Amazon and future retail scenario, the panel would be discussing the developing contours of emergency arbitration in India. We have the good fortune to have Honorable Ms. Justice Hima Kohli to chair the session. Justice Kohli is a judge of the Supreme Court of India. Before her elevation to the Supreme Court, she was the Chief Justice of High Court for the state of Telangana. Amongst her many achievements, she has been the Standing Counsel and Legal Advisor of the New Delhi Municipal Corporation in the High Court of Delhi. She has also been the Additional Standing Counsel, Civil Government of National Capital Territory of Delhi in the High Court of Delhi. Apart from performing her official duties as a judge, she takes a keen interest in promoting mediation as an alternate dispute resolution forum, in highlighting the role of judiciary, in preserving of the ecology and environment, and the role of family courts in resolving family disputes. Joining her in the panel, we have Honorable Mr. Justice Nambiar. Justice Nambiar is a judge of the High Court of Kerala. He commenced practice as a lawyer in 1990 with Messrs. Menon & Pai Advocates, a leading law firm in Cochin. Specializing in constitutional law and taxation, direct and indirect, he was designated as a senior advocate of the Kerala High Court in July 2011 before being appointed as a judge of High Court of Kerala in 2016. We also have Mr. K.V. Vishwanathan with us. Sir has had an illustrious career for over 32 years. Designated as a senior advocate by the Supreme Court in 2009, Mr. Vishwanathan has appeared in several reported cases in diverse branches of law, like constitutional law, criminal law, commercial law, securities law, insolvency code, arbitration, etc., before the Supreme Court and High Courts throughout India. He was appointed as the Additional Solicitor General of India in 2013. Mr. Vishwanathan is also the advisor to Delhi International Arbitration Center. Last but not the least, we have Mr. V.K. Rajah with us. Mr. Rajah commenced his legal career with Rajah & Tan, serving as managing partner from 1987 to 2003. In 1997, he was appointed senior counsel in Singapore. Mr. Rajah was elevated to the judge of appeal in 2007. In 2014, Mr. Rajah left the bench to assume office as the Attorney General of Singapore. Mr. Rajah has currently chosen to work exclusively as an international arbitrator. May I now request the chair to please come forward and address the audience.
You can do it. I think you have to sit down.
A very good afternoon to all of you. It's always a pleasure to visit this court, and particularly the new S block. The connect with this court goes back to my starting days in the practice and continues till now. I would say the umbilical cord never did get disconnected. Distinguished guests on the dais and in the audience, ladies and gentlemen, my colleagues, good afternoon. The subject of the session, as you all know, is emergency arbitration and its developing contours in India. Today, the world is moving faster than ever before, and with increasing globalization, there has been an exponential growth in commercial transactions. Businesses are expanding at a tremendous pace, crossing geographical and cultural boundaries and creating new and diverse challenges. With these advancements, resolution of disputes has become increasingly important, as these disputes can impact not just the parties involved, but also the global community at large. It is in this context that the concept of emergency arbitration, EA, also known as expedited arbitration, has emerged as a critical mechanism for resolving a part of the dispute that may require an urgent resolution prior to the proceedings commencing before the arbitral tribunal or during the course of such proceedings. This session, which is addressing a niche subject, shall throw light on the importance of EA, its relevance in India, the approach of the Indian courts, development in the foreign jurisprudence to the problems faced here, and it offers, as EA offers a quicker resolution and avoids the delays as also the expenses that are associated with traditional arbitration. Despite its growing popularity and the need of EA in India, there are several challenges that are required to be overcome. Before we go to it, I'll start with the facets of EA. EA is a facet of alternate dispute resolution that provides quick and efficient solutions to disputes that otherwise are subject matter of arbitration. It is a process where a temporary arbitrator is appointed to hear and resolve pressing disputes within a short span of time, usually within a few days or a few weeks. The process of EA is intended to provide a quick and an efficient solution to urgent disputes that require immediate attention, and they cannot wait for the conclusion of normal arbitration proceedings. One of the key advantages of EA is its speed and efficiency. Unlike the traditional mode of arbitration, which can take months to resolve, EA can provide a solution in a matter of days or weeks. It makes EA an ideal solution for disputes that require an urgent resolution, such as those involving breach of contracts, preservation of assets, or preservation of evidence. Another advantage of EA is the confidentiality that is attached to it. Unlike traditional courtroom disputes, which is in public spaces, EA, like an arbitration matter, and it is a facet of it, is conducted in private. It allows parties to keep their disputes confidential, which is particularly important for big business houses and corporate sector, where they want their disputes to remain out of public domain, keeping in mind their negative impact on their reputation as also their brand image. Use of EA in India is growing, particularly due to the increasing awareness of the benefits of the ADR methods. To avoid the long and cumbersome process of civil litigation, many businesses have been resorting to arbitration as a favored ADR to resolve their disputes. EA, being just another facet of routine arbitration, is the next step and the next level, as it provides an efficient and effective solution to these problems, a quick resolution, as also avoidance of delay and expenses that are associated with traditional arbitration. So despite its growing popularity, there are several challenges that must be overcome by this particular niche area of EA. One of the biggest one is the opacity in the rules and the procedures. Till the procedures of EA is standardized in India, it can cause confusion and inconsistencies which are avoidable in a manner in which the cases are handled. Parties will find it difficult to understand the process, which itself can lead to delays in resolution of disputes. So, clarity and consistency of the rules and the procedures is important. Another challenge is the lack of awareness among the stakeholders about the availability of the mechanism of EA and its benefits, as many parties are still unaware of their alternative dispute resolution mechanism. They can miss out on the benefits EA provides. This lack of awareness is a significant barrier to the growth of EA in India, and it is important that efforts are made to educate the parties about this unique feature of ADR mechanism and its efficacy. And therefore, I would think that I must commend the organizers of this particular program that they decided to dedicate a session specifically to EA. The concept of EA is not new to many other parts of the world. In fact, it has been around for several years abroad and has been used by a variety of countries, whether it is the US or UK or Switzerland, so on and so forth, many parts of Europe. But in India, this concept is relatively new and has only recently gained traction as a preferred mode of resolving disputes between parties who have opted for the ADR mode. EA is a procedural innovation born out of the need to make arbitration more self-reliant. Previously, as you all know, parties had the option of approaching courts for interim measures under Section 9 of the Arbitration and Conciliation Act, which was a stage prior to the constitution of an arbitral tribunal. Now, EA offers parties another avenue to obtain urgent interim relief, not only at the pre-arbitration stage, but also during the course of the arbitration. In circumstances where members of the arbitral tribunal, for various reasons, may not be readily available to assemble and conduct a sitting right away, it provides an answer. The option comes with many advantages, such as ensuring appointment of an emergency arbitration within one flat day of filing of the application, or rendering of orders in a time-bound manner. The relevance of EA can be seen by the fact that it has been introduced into the rules of arbitration by institutions like SIAC, ICC, HKIAC, to name a few, and in India, the Delhi International Arbitration Center, the Mumbai International Arbitration Center, the International Arbitration and Mediation Center at Hyderabad. Access to EA depends on whether parties have elected institutional arbitration as opposed to ad hoc arbitration for resolution of their disputes. In the case of India, there has been a growing reliance on institutional arbitration. Statistics reveal that Indian parties are the top users of SIAC. The Arbitration and Conciliation Amendment Act of 2019 has also provided an impetus to the institutional arbitration system in India by delegating appointment of arbitrators to designated arbitral institutions, by providing for confidentiality and limiting the timeline for conducting the proceedings, which is in line with institutional rules. In this backdrop of the developments, EA has received a fillip and naturally become more relevant in our country. There are concerns over the validity of EA. I'll touch upon a couple. The first concern of the validity is the legitimacy of the process itself. This is owing to the background in which EA has evolved, which is through amendments to institutional rules. It has yet to find a specific mention in the Arbitration and the Conciliation Act. This is in contradistinction to Singapore, where the amended Singapore International Arbitration Act 94 provides for enforcement of Singapore-seated emergency arbitral awards by expanding the definition of arbitral tribunal. Similarly, in Hong Kong too, the arbitration ordinance has been amended to explicitly allow for recognition and enforcement of emergency relief in both domestic and foreign-seated arbitrations. Borrowing a leaf from these developments, the 246th Law Commission report did recommend broadening of the definition of an arbitral tribunal under Section 2(1)(d) of the Act to specifically include emergency arbitrator, though it wasn't followed up through legislation. One of the primary concerns plaguing the development of EA in India is the enforcement of orders passed by an emergency arbitrator in courts. As I said earlier, EA may be seen as a parallel mechanism for grant of interim release prior to constitution of an arbitral tribunal and an option to avoid approaching courts directly for interim relief. However, the emergency arbitrator is still not a judicial authority like the court or a statutorily recognized one like the arbitral tribunal. The emergency arbitrator is an individual appointed by the president of the institution whose rules run the arbitration proceedings. Her mandate expires within a fixed time period, after which she cannot be appointed as an arbitrator unless and until it is with the consent of all the parties. The EA order or the award ceases to be binding if a tribunal is not constituted within 90 days of passing of the order or the award. These are difficulties that raise a question on the status of the orders passed by an emergency arbitrator and the consequent enforceability. What are the challenges of EA? To my mind, and I'll name just a few, the foremost challenges: recognition and enforceability. There may be a probability that a country might recognize the provisions of EA and enforce the order passed by an emergency arbitrator, but a court of a different jurisdiction might not be in a position to recognize or to enforce the same due to absence of specific legislation which recognizes an order passed by an EA. EA is an interim binding award, and once the arbitral tribunal is constituted, it is not binding, and in case any other person is appointed as an arbitrator to the substantive tribunal, it is the latter who can vary or suspend the order in case the time stipulated for such an award has not expired. The form of interim relief can also play a role, particularly when interim relief granted by the emergency arbitrator is in the form of an order rather than an award. Another aspect is the uncertainty of the consequences of non-compliance of an order made by the emergency arbitrator. So although Article 29(2) of the ICC rules requires parties to undertake to comply with an order made by an emergency arbitrator, the same is silent as to the consequences of non-compliance. Parties may manage to get interim orders in their favor, but they would have perhaps still to struggle to get an enforcement which needs the support of a court system and of that particular jurisdiction, meaning thereby they are again dragged into litigation which they never intended to go in for the first place. Fourth, the emergency award, as the law stands today, is in a foreign-seated arbitration is not enforceable in India. A party armed with an emergency award would still have to file a Section 9 proceeding under the Act requiring the relevant Indian court to independently assess whether the interim relief ought to be granted to a party or not. The emergency award may have some persuasive value for a court, but it would not bind the court in that sense of the term. Again, the definition of the Arbitration Act, as I mentioned, excludes expressly the term emergency arbitrator. So the emergency arbitrator remains transient in his or her authority and ceases to exist after constitution of an arbitral tribunal. This will result in parties appointing different set of arbitrators at different points in time. The Act does not contemplate appointment of temporary arbitrators, in other words. Recognition of EA will serve some objectives that I'll touch upon. It will support the growth of institutional arbitration in India. In addition to international arbitral institutions, many domestic arbitral institutions have provided for EA, and a final ruling in favor of EA will be a much needed shot in the arm for institutional arbitration in India. Recognition of such a mechanism will be in line with the principles of minimal judicial intervention in respect of arbitration proceedings, a principle that is enshrined in Article 5 of the Uncentrol Model Law, which has been incorporated in Section 5 of the Indian Arbitration Act. There will be a rise in India's seated arbitral proceedings if the orders passed by an emergency arbitrator are held to be enforceable under Section 17(2) of the Arbitration and Conciliation Act, which is presently available only for India-seated arbitrations. International parties may seriously consider choosing India as a seat of arbitration. Recognition of EA will also be consistent with the two familiar pillars of arbitration, party autonomy and efficiency. Concomitant with the rise of institutional arbitration, recognition and enforceability of orders passed by an emergency arbitrator will help in reducing the docket explosion faced by Indian courts that are already overburdened. So how have courts engaged with all these issues that I've touched upon are aspects that the speakers of this session will address us on. I'll start by requesting Radhika to weave the thread through and hear my colleagues on the dais. Thank you.
Thank you so much, ma'am, for such insightful thoughts. May I now call upon Mr. V.K. Rajah to please address the audience.
Good afternoon, everyone. It's a strange sensation sitting here today and literally raking over the coals of a decision I made over a very long weekend more than 2 years ago. I did not expect, I can say, to be here 2.5 years later discussing one aspect of the case that has captured the most attention. There were actually about 12, 14 different points argued by an army of some 60 lawyers representing some 5 different parties. But it has been an interesting journey, and I've followed intermittently the meandering that these proceedings have taken. I had no further interest in the matter after I delivered my decision, except an academic interest and as a keen observer of developments in the international landscape. So I'm not going to reiterate or cover what Justice Kohli has so comprehensively covered in the last 15 minutes. But I'd like to perhaps do a little legal archaeology to explain how we have come to this present state of affairs and what might lie ahead. So the idea of having an emergency arbitrator first started taking shape in the 1990s, and it was default. It was not a default procedure, it was an opt-in procedure initially for some arbitral tribunals, and including WIPO. In 2006, the ICDR, which is the international arm of the AAA, for the first time made the appointment of an emergency arbitrator a default mechanism. In other words, you had to opt out of it for it not to apply. And that very quickly became viral. In quick succession, the Hong Kong, the Singapore, the London, and then the ICC, a little slower, adopted these procedures. And to date, almost every institution, I think except ICSID, they still don't have emergency arbitrator procedure, and for good reason, because it involves states, and the stakes are much higher. And the state is not going anywhere anyway. So in terms of assets being lost or frittered away, that's usually not an issue unless the state goes bankrupt. So, so there we were. Now, what happened when these rules came into force? Many in the arbitral community realized that there would be a problem when it came to enforcement, because when the New York Convention was first drafted, no such creature came or was in existence or even contemplated. There also was strong predisposition, and there still is, to read the award as only applying, the convention as only applying to final awards rather than to orders. So many countries, on advice from members of their arbitral community, amended their statutes immediately. Well, I shouldn't use the word immediately. It took about a few years, 3, 4, 5 years, to recognize to give statutory force and recognition to emergency arbitrators and to the awards or orders that they made. And those countries include Hong Kong, Singapore, and so on. India too, as you have heard from Justice Kohli, first your Law Commission and then the Sri Krishna report had suggested that your Arbitration and Conciliation Act be amended to recognize the office of the emergency arbitrator and also to ensure that orders made would have teeth. Now, we have no explanation as to why this was not taken up or accepted. I hypothesized in my award that this could be because it might amount to gilding the lily, that they might have thought that it might have been unnecessary. But if we'll deal with and my two colleagues here, Justice Nambiar and Mr. Vishwanathan, are better placed than me to offer interpretations of the Arbitration and Conciliation Act. But the fact of the matter is, I'll be very direct, it is always better to amend a statute than to leave it to the courts to find a solution. And if India, as many here have said, both the politicians as well as leading arbitral thought leaders, that India's intent on becoming arbitration superpower, it would be better not to leave these matters opaque. And I would strongly urge those responsible for improving the arbitral landscape to give clarity to this area. I mean, Justice Kohli very rightly pointed out there is some question, it's a gray area. I think Justice Kohli was a little more categorical. She said no, but let me say it's a gray area because all of you here want to have room to argue as to whether a foreign-seated arbitration, because in Amazon, it was an Indian-seated arbitration, and that made it easier for me to take a purposive approach which was vindicated by first, and I want to acknowledge Justice Mida here, because he was the High Court judge whom everyone seems to have forgotten, and Justice Nariman in his, and I'm not saying this because he upheld the view that I took, but in his extremely erudite and comprehensive decision, took a purposive approach, which I think accorded with both the legislative intent, pragmatism, and also it firmly placed India in the eyes of the arbitral community as being a progressive as well as a pragmatic arbitral center. I think that decision was extremely important for the Indian judiciary, for the Indian arbitral community, because I think it reinforced the view taken post-Balco, that the Indian arbitral community, the Indian judiciary, were intent in going mainstream and adopting best practices from around the world. Now, post-Amazon, we still have problems. The first problem, which is peculiar to domestic arbitration in India, is that your ad hoc arbitrations will not be able to avail themselves of this instrument or this procedure. And that's another reason why corporate counsel, when drafting the contracts, should provide for institutional arbitration. I understand the Delhi Arbitration Center, the Mumbai Arbitration Center, and the Chennai Arbitration Center have already inserted clauses in their rules to provide for the appointment of emergency arbitrator. The other rule that doesn't provide for emergency arbitrators, and those of you who are practitioners are probably aware of it, if not, please bear it in mind, is the UNCITRAL rules. So if you adopt in an ad hoc arbitration the UNCITRAL rules, you will not be able to appoint an emergency arbitrator. So I think the gray areas at the moment that exist in India, which my two colleagues will no doubt address would be first, the appointment or the recognition of an emergency arbitrator in a foreign-seated arbitration. So many of you have come up with different techniques to try and address this, inter alia by combining it with a Section 9 application. The other interesting problem that you might want to think about, and I would suggest you do not risk it, is doing an ex parte application before emergency arbitrator. Now, the Swiss rules recognize the possibility of doing an ex parte application before an emergency arbitrator, and I would assume that would happen in a case where there's a real risk that if the opposing party is informed of the proceedings, it might take steps to dissipate its assets even further. But I think most courts would be very concerned about recognizing, even in the domestic sector, such a order, except in the most exceptional circumstances. So that's something you might want to think about. The other problem, another practical problem that you will have in the appointment of emergency arbitrators is if there is a heavily contested jurisdictional battle. Most emergency arbitrators would be extremely slow in such a matter if there is a good case to suggest that jurisdiction might not be established to then go on to make an order. So there are many positive features about the emergency arbitrator scheme, but at the same time, I think one must be extremely aware of the limitations. What one could do, and I'm trying to be practical now, is in India, you can always resort to the courts, but this might not be so easy when it's when the seat is outside India and the assets are in many different jurisdictions. One has to be then extremely careful in terms of how one goes about it. But I would assume that one would decide which are the jurisdictions under the most threat, and most countries in the world now have court-assisted procedures in aid of arbitration, and I would probably opt for that rather than go for an emergency arbitrator and then facing all sorts of difficulties in getting it recognized in several different jurisdictions at the same time. Now, I'm very conscious that I may have outlasted my welcome, so I'm going to shut up now and let my two colleagues continue, but I'll be happy if there's time to either take questions or to further amplify my thoughts. Thank you very much for listening.
Move on to Mr. K.V. Vishwanathan and request him to please come on to the dais and share his thoughts.
My Lord, the Honorable Justice Hima Kohli, my co-panelists, Justice Jayasankaran Nambiar and Mr. V.K. Rajah, dignitaries of the dais, Justice Sundar from the Madras High Court, Justice Naveen Chawla, Justice Midda, Justice Ganju. Ladies and gentlemen, a very good afternoon to you. After that comprehensive elucidation by Justice Kohli, whatever one may want to say is bound to pale into a little insignificance. I think the problem, ma'am, is also in the surname. When they take center stage, the batsman following will have to do that extra bit to make a mark. Now, coming to the topic, it is a given today that emergency arbitration is needed. But how does it fit in the statutory scheme that we have? What has our courts done? What have the courts in other jurisdictions done to handle this scenario? Because I have identified two basic problems that will arise in the enforcement of an emergency arbitrator's order in a foreign-seated arbitration. Now, before we get there, as far as the Indian scene is concerned, the Act expressly doesn't recognize an emergency arbitrator. So when the issue arose in the Delhi High Court first, I mean, these are all well-established facts, but this prefatory note is essential to get to the meat of what I want to really discuss with you, was in the case of Section 9 to reinforce an order of an emergency arbitrator which had ordered an interim measure in favor of the party. So Justice Bakru, our president, speaking for the Delhi High Court in a very erudite judgment, said that merely because an emergency arbitrator is ordered one way, it would not foreclose a Section 9. India having not adopted the UNCITRAL recommendations in 17H, 17I, the only option open to the party was to move a Section 9. But that was in a foreign-seated arbitration. Ashwin Minda soon followed. That was a case of a party which had failed in obtaining an emergency arbitrator's order. Court said, no, having elected there, you can't come with a Section 9. Raffles was distinguished. Then came Amazon. Amazon was a India-seated arbitration. Question arose whether an emergency arbitrator is an arbitral tribunal. We argued that ouster has to be strictly construed. Section 28 of the Contract Act would only oust the civil court if it is expressly provided. But Justice Nariman would have none of that. In a judgment interpreting 17(1), he said that tribunal would include an emergency arbitrator. Now, if that logic is to be extended, there is no reason why, on the same purposive construction that he has taken, why it cannot be extended to Part 2 arbitrators, notwithstanding the fact that India has not adopted 17H and 17I as noticed by Justice Bakru and repeated in Amazon in para 34 of the judgment. Digressing a bit, correct me, Mr. Rajah, if I'm wrong, Singapore had an issue, and I did have occasion to see the High Court's judgment. I don't know whether it went up further. Singapore had an amendment to the definition section in Part 1 there, which included an emergency arbitrator to be part of the arbitral tribunal. But the question was, would that definition extend in a recognition and enforcement proceeding of a foreign-seated arbitration? The court said we will adopt a purposive construction, extend the definition to foreign-seated awards and apply what our 48 is, your equivalent of 31, and said subject to the gateways of that section, we will enforce it. Now, without a legislative intervention wholesale, if you attempt this, there are bound to be some incongruities. And as Mr. Rajah rightly said, these are best addressed with specific amendments. And I'll tell you why, correct me if I'm wrong. The gateways in 48 have one important clause which the UNCITRAL clause carefully excluded for enforcement of interim measures. That is, you don't have to wait till the award is binding. And an award is not binding at least till the period for its enforcement or to challenge, period for its challenge has expired. Now 90 plus 30, 120 days in India, it must be a similar provision in whichever is the foreign seated arbitration. Now when you apply a purposive construction and you extend this, you can't leave alone this portion and say that no, clause 5 we will exclude it. The UNCITRAL rules carefully excludes it. And if I may draw attention to 17H, which is not incorporated, and it is best incorporated, notwithstanding the fact that we canvassed against the recognition of emergency arbitrators in the Act. I, for one, is a votary for emergency arbitration. But if you have to do it, you have to do it properly. 17H of the UNCITRAL rules says, recognition and enforcement. An interim measure issued by an arbitral tribunal shall be recognized as binding and unless otherwise provided by the arbitral tribunal, enforced upon application to the competent court, irrespective of the country in which it was issued, subject to the provisions of Article 17I. Now, what is 17I? Grounds for refusing recognition or enforcement. Recognition or enforcement of an interim measure may be refused only at the request of the party whom it is invoked if the court is satisfied that such refusal is warranted on the grounds set forth in the UNCITRAL Article 36 1A1, 1A2, 3 or 4. Now if you see the equivalent of it in India, section 48, 48A would be parties to the agreement referred to in 44 were under the law applicable to them under some incapacity, no problem. Party against whom the award is invoked was not given proper notice, fair enough. Award deals with a difference not contemplated by or not falling within the terms. Composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. And E, the award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which the award was made. Now apply this if it is an interim measure, subject to the equivalent of our 37 it would be. To that extent, one will have to wait. So you can't say that you apply A to D in a truncated manner, leave alone E. So that is one incongruity which the legislation may have to address. But more importantly, the second aspect which I want to highlight is, what is the nature of relief that the emergency arbitrator can give? He can give prohibitory orders as presently advised, if you are to apply the 17 logic, and mandatory orders of injunction. And as Justice Kohli said, emergency arbitration orders have its limitation. You will have to soon thereafter apply for constitution of the tribunal. Its validity is for 90 days unless it is varied, and if the tribunal is not constituted, it ceases to come into force. Now, in an order which is so incoherent, it is best advised that the legislature steps in and, like it is done in Hong Kong, prescribe the nature of interim reliefs that an emergency arbitrator may also grant. 22B2 of the Hong Kong Arbitration Ordinance says the court may not grant leave to enforce any emergency relief granted outside Hong Kong unless the party seeking to enforce it can demonstrate that it consists only of one or more temporary measures, including an injunction by which the emergency arbitrator orders the party to do one or more of the following: maintain or restore the status quo pending the determination of the dispute concerned, take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself, provide a means of preserving assets out of which a subsequent award made by an arbitral tribunal may be satisfied, preserve evidence that may be relevant and material to resolving the dispute, give security in connection with anything to be done under para A, B, C or D, give security for costs of the arbitration. Not what our 17 now says, namely, Such other interim measure or protection as may appear to the arbitral tribunal to be just and convenient, the arbitral tribunal shall have the same power for making orders as the court has for the purpose of and in relation to any proceeding before it. So, for two reasons, I would join Justice Kohli and Mr. Rajah in canvassing that legislative intervention is the immediate desideratum to avoid any confusion. Otherwise, lawyers will be smacking their lips, because if an enforcement is to come of a foreign-seated emergency arbitrations award, all these issues are bound to crop up. Justice Nariman carefully in para 34 said Rifles was a foreign-seated arbitration, and the learned judge noticed the legislative vacuum. He reiterated that position and only confined his case to a 17-1 scenario. So my suggestion would be that while we welcome emergency arbitration, because it does, as we are aware and as Redfern and Hunter also noticed in their commentary, constitution of tribunals take time. Parties may be given an option to nominate, they may delay, there may be default nominations, but pending that, urgent orders have to be obtained. Urgent orders are required to preserve the status quo, as otherwise assets could be dissipated. But consequential provisions for enforcements, otherwise the victory for a party would be a Pyrrhic victory, it would be a brutum fulmen, it will not be effective. So legislative intervention, as was suggested by Justice Kohli and seconded by Mr. Rajah, is an immediate desideratum. Now, the point about ad hoc arbitrations, it is impossible now, you can't even conceive of having, it's confined to institutional arbitration. Amazon recognizes that, but we do recognize ad hoc arbitrations, but I think slowly and steadily it will gravitate towards full-scale institutional arbitrations. The Delhi Arbitration Center already has provisions for emergency measures, but what is important is, unlike in Singapore, this is the judgment I had in mind, Mr. Rajah, CVG and CVH, which adopted the purposive construction to extend the definition of arbitral tribunal to Part 2 arbitrations and say that that will also be an arbitral tribunal for the foreign-seated arbitration. That is bound to create a lot of confusion. The purpose will be defeated. So my contribution for the day, subject to your countenancing it, is that the sooner we amend the statute, the better it is. I am leaving a little time for questions so that, instead of a sermon, it is best discussed. Thank you very much for the opportunity.
Thank you so much, sir, for sharing your views. May I now call upon Honorable Mr. Justice Nambiar to please give his address.
Justice Kohli, fellow panelists, my good friend Mr. Vishwanathan and Mr. Rajah, fellow judges of the High Court, and my dear friends in the legal fraternity. I second the view of Mr. Vishwanathan as regards the tone and tenor of the introductory speech. He was very charitable in saying, or drawing an analogy with cricket. I'd go a step further. I'd say that it was a complete usurpation of the jurisdiction of other authorities by the Supreme Court. After that mega introductory speech, I don't think we have much to discuss here. But the perspective that I'd like to bring to today's discussion is that of a sitting judge of a high court in a state which is far away from Delhi. And as a person who's missed all the action as a litigating lawyer in the last decade or so, which is when the major developments in arbitration actually took place in India and abroad. Now, before, I'll let you in on a secret, before we got in here, we had actually planned an allocation or a division of labor, as it were. And as is common in every panel which consists of lawyers and and judges, we decided to throw the lawyers under the bus. So that's why you got both these gentlemen sitting on either side speaking first. Now, I also had an opportunity, since I'm in Delhi, to actually sit in on some of the other sessions. And when I was just looking at the topics that were being discussed, I thought it would be, in order to just recap, finding that it's a very narrow subject that we're discussing here. And I just wanted to bring a different perspective. Anything in the arbitration law that we're discussing should bear in mind that there's a conceptual difference between arbitration law and court litigation as we know it. And that essentially is that you need to bear in mind that dispensation of justice in a court of law is largely an aspect of governance of the state. So the judiciary is actually an organ or a branch of the concept of state, as it were. And when you're actually deciding cases in a court, the primary objective is to actually maintain law and order in society. The settlement of the actual dispute between the parties is only secondary, is incidental to the main object. Whereas, and therefore, when you go to a court, there is a certain inflexibility brought about through a uniformity or an objective uniformity in the procedural laws, which cannot be broken in individual cases. And that's precisely why people started choosing an alternative system of redressal and enter arbitration, mediation, etc. Now, when you're talking about the objects of arbitration, the story is inverted. You now have a settlement of the dispute between the parties being the primary object of arbitration or mediation. And maintenance of law and order in society is just incidental. More importantly, the party autonomy principle ensures that you get to choose a particular procedure, and it's only regulated by the currile law that you have. So, if you have all these benefits which you can choose as parties, then why have a state machinery at all? And this is where things get tricky, because in the earlier session with Justice Muralidharan and others in the panel, there was this whole debate about, public policy, the distinction between public interest and public policy, and whether we should actually start enforcing awards between two persons when the subject matter of dispute is whether you should get kickbacks, whether you should earn those kickbacks, etc. Now, this is where the importance of enforcement of arbitral award comes in. And you require the state machinery to actually enforce it. And therefore, the degree to which national courts would actually intervene in enforcement would depend upon the agreement between the parties, but an intervention is necessary if you want to enforce the award. Right. Given that you do require the national courts to act at some stage, you have the definitions of, or you have the concepts of the currile law, which would govern or supervise the arbitration, which in turn is determined by the seat of arbitration. Now, all these are matters in the last 7 or 8 years. You had a number of decisions of the Supreme Court. I'm not going to go into all of them. You've had a number of decisions which have, thrown this whole thing into a confusion. But eventually, I think now we're fairly, it's fairly well settled now that after Balco and BGS, SGS, SOMA joint venture, the courts having jurisdiction over the seat of arbitration have exclusive supervisory jurisdiction, because there was this dispute as to whether it is exclusive or concurrent, and I think that's now settled. A similar set of disputes which came in the context of determining the seat of arbitration, whether the seat would always follow the venue that was indicated by the parties or not. Well, that has also been settled now after we adopted the Shashwa principle, endorsed again in Balco and BGS Soma. A slightly contradictory, contrary view taken in Mankatsu Impex, but we won't go into that as well. The subject of today's discussion features more around interim measures. And when it comes to interim measures, there's a significant, as you all know, there's a significant difference between the applicability of Section 9 when it comes to Indian-seated arbitration and foreign-seated arbitrations. Broadly stated, the provisions of Part 1 of 96 Act, including Sections 9 and 17, and I'm stressing only on 9 and 17, apply no doubt to domestic-seated arbitrations. And after BALCO, until the amendment in 2016, Part 1 did not apply to foreign-seated arbitrations. But then comes the amendment in 2016, and you have the provisions of Section 9 being made applicable even to foreign-seated arbitrations, whose awards, of course, if those awards are enforceable under Part 2. Now the waters get a little murkier. Both domestic foreign-seated arbitrations and application for interim relief can be preferred under Section 9 before the civil court, before or during the arbitral proceedings, or after the award but before the enforcement. 9.2 and 9.3 which were introduced. 9.2 says that if you've approached the civil court and you've got an interim measure, then within the next 2 months you have to actually constitute the arbitral tribunal. 9.3 goes further and says once you have an arbitral tribunal constituted, then you can't go to the civil court thereafter. And obviously the rationale behind that was that once you have an arbitral tribunal, then you go under Section 17. Right. It's in the middle of all this that you have this concept of emergency arbitration. Now, take a moment to think at what is the stage at which one goes for emergency arbitration. It is a stage at which you have commenced the arbitral proceedings, but before the arbitral tribunal has been constituted. So it's that window, which otherwise would be covered by Section 9 here. Now, Section 9, had it not been for the amendment, this would have been confined, this benefit would have been confined only to the domestic seated arbitrations. But mercifully, we've got the amendment, makes it applicable to foreign seated arbitrations. Now, any talk about emergency arbitration in India today must begin and end with futures, Amazon and futures. And you have two people who played a vital role in the shaping of that judgment, whether or not it was to their liking, I do not know. But you have Mr. Vishwanathan and Mr. Rajah, who was the emergency arbitrator there. Now, the long and short of it is that if the institutional rules permit the emergency arbitration, then if the parties, unless the parties have not expressly excluded its applicability, you can have recourse to that. And the important thing there is the Amazon case was a case of a domestic seated arbitration. Now, what did the Supreme Court do? It basically said that the emergency arbitration award will be treated as an interim order passed by the arbitral tribunal for the purposes of Section 17(1). It went on to say that that could be enforced under Section 17(2). And then went on to say that the award and its enforcement will not be appealable under Section 37. Now, my queries as a judge, because at the end of the day, these are matters that are going to come before us, and I'm no longer a litigating lawyer, so now I have to actually take a decision one way or the other. My questions are threefold, and I'm hoping that my friends on either side would provide me with an answer. By equating an emergency arbitral award with an interim order of an arbitral tribunal under Section 17(1), first and foremost, are we not ignoring the statutory scheme under 1996 Act that up till the stage of constitution of the arbitral tribunal, it's only a civil court that has the power to order an interim measure under Section 9. Because Section 17 does not really come in till the stage when an arbitral tribunal is constituted. Now, this was my first question. It is kind of answered in futures by saying that we're going to be treating this emergency arbitration award as an award of an arbitral tribunal for the purpose of Section 17. Fair enough, that's one way of looking at it. But then that brings me to my second question. When you have when you've already held and already taken a view that in a foreign seated arbitration, Section 17(1), which falls under Part 1, will not apply. Because you will recall that the amendment to get over the Balco judgment of Part 1 not applying to foreign seated arbitrations, the amendment brought in a specific application of sections 9, 27 and 37 only to foreign seated arbitrations. If you're going to be treating this as an arbitral award, interim arbitral award under section 17, how is that going to fit in when 17 itself is not going to be applicable in the case of foreign seated award? That's my second question. And third, and this is something I've never been able to understand in the Amazon judgment, is that if orders of a civil court under section 9 and orders of the arbitral tribunal under section 17 are appealable under section 37, then why is it that an emergency arbitrator's award in a domestic seated arbitration not appealable under section 37? And of course, the logical extension of that would be, if you're making part 1 applicable to foreign seated arbitrations and an emergency arbitral award is passed, and you implement that as under section 17 here, and by some amendment you bring section 17 within part 1, applicable to foreign seated arbitrations, why wouldn't that not be appealable? So these are the three questions I want to leave you with, and hopefully my fellow panelists will answer the biblical question, quo vadis domini, in the context of Indian arbitration law. Thank you.
Thank you so much, sir, for sharing your thoughts with us. We'll now open the house for question and answers, but please restrict your questions to being short and pointed. The gentleman there.
I am Ramesh Kumar. I am working with Maharatna Public Center Undertaking. My question is that whether emergency arbitration would include ruling on specific performance of sale of goods, the goods being public utility goods.
The whole focus of an emergency arbitral award or an arbitration proceeding would hinge on the subject of dispute, which is a subject matter of arbitration. So if that particular sale of good or a dispute with regard to sale of good is the foundation of the contract where there's an arbitration clause, then anything which is emergent relating to that dispute would be open to emergency arbitration. I should.
I would strongly advise Justice Kohli, and I think it would apply to me as well, that we don't answer any questions, because I realized to my horror that there is this transcript thing going on here. And tomorrow, the last thing we want is somebody taking a printout of that and coming to us in court. Like, you answered this. Res judicata.
So we are warned, and we still proceed with Q&A. So another question that the House may have to throw. Yes, there is this young lady there. Please hand over the mic to her.
I already had the mic. Good afternoon, everyone. My question is, in the Indian context, what is really the relevance of emergency arbitration when we have the remedy of Section 9 and 17 available?
See, Section 9 is a concurrent remedy. Parties who are here can always avail that. But as you saw in future, they had an arbitration agreement with the SIAC rules being the governing rule. So that remedy was availed. So a party wanting to avail a Section 9 can avail a Section 9. But what if a party avails the emergency arbitrator provision of the governing rule and then brings it up for enforcement? So you're right, real problem will arise in foreign seated arbitrations, because even though, as Justice Nambiar pointed out, Section 2 is amended to say that 3 sections are made applicable unless expressly excluded. in the 2015 amendment, post Balco, which overruled Bhatia and Venture. But this will be a concurrent remedy for all. Amazon could have availed Section 9. In fact, we argued that they did not avail 9. But they had a right under the CAC rules to move it. So,
if I can just
as Minda says, once you avail that and you lose, then you can't come back to 9. But Raffles for foreign seated says if you get that, you can still come under 9 because enforcement is a grey area. So all this will be worked out only by legislation intervenes. But you're right, it will be a concurrent remedy for a party to elect.
If I can just add to that, your question was why would you want to go for emergency arbitration? I think that's begging the question because the whole concept of emergency arbitration comes in because of the need to declog the courts. So parties found that although they had a remedy under Section 9, it was not efficacious. And that's why you have a emergency arbitration clause.
Just to, sir, with your permission, supplement to what has been already said by the panel. Section 5, as Justice Nambiar mentioned, is minimum judicial intervention. And add to that, the practical part of Section 9 is getting, as lawyers, we understand, getting the matter listed, then who is it going to be before. All that also comes into picture. Anyone else has questions?
I have a question. This is what Justice Nambiar said. You see, emergency arbitrator as per the Act is challengeable before the under 37. So the Supreme Court in future has not said that the order is not challengeable. In fact, the order was not challenged.
Enforcement is not.
No, it was the enforcement which was filed, and that interim order in enforcement was challenged in appeal, and the Supreme Court only said that the interim orders are not challengeable. But I think it was also somewhere clarified that they had the remedy of challenging in appeal. So the emergency arbitrator award is also challengeable in appeal under 37, like the orders under Section 9, as well as the interim orders under 17(1).
The 37 would lie.
Yes,
What they said was the enforcement order would not be applicable in LP.
Interim order of enforcement is not challengeable because the Act doesn't provide for appeal. So they only said that order is not challengeable.
Yes,
but not that the party there had not availed the remedy of filing an appeal against the emergency arbitrator, which remedy was there. And I think it was also
We
availed.
wanted Justice Midda's order to be challenged in division bench.
Thank you.
Give the mic, please.
I attended UNSA trial for its debates on interim relief, and I am presently suffering from PTSD that's about 15 years old, because the debate that is going on here is the debate that went on at UNSA trial about why would you want an emergency arbitrator when you have interim relief from the courts and everything. And all of those arguments were effectively pushed to one side. In terms of archaeology, Howard Holtzman very much pushed emergency arbitration and introduced it to the ICDR on the basis that if a commercial court could do it, then muscular arbitration should be able to do it as well. To intervene on the specific issue that was being debated here, of course, an emergency arbitrator's order ceases to have effect once the substantive tribunal is appointed. And so the interesting issue for India, I suspect, will be if an application is made under Section 9, I would assume, then it takes effect as an order of the court under Section 9, and Justice Kohli addressed the issue of whether or not that is persuasive in Section 9 or in enforcement. And I think there's other jurisprudence in other places that it's just persuasive. The interesting question will be, will you have two orders running off in parallel? Section 9 order, which then has to go through the court proceedings, and the emergency order, which then disappears the moment the substantive tribunal appears, for the substantive tribunal either to confirm or vary. But anyway, this is just like reliving everything we had at UNSA trial 10 years ago, 15 years ago.
Some rules say that if a tribunal is not constituted, it will cease to have effect. But if it is constituted within a time, then it may have to be varied. Some rules provide. I saw the Japanese rule which we dealt with in Minda. that had a clause that if it is not constituted, and if within 10 days you don't give an application for nomination, if it is not part of the, if you only go for EA and not the claim, in some cases they move the claim and this one. But then it lapses. But if it is constituted, and then you have to vary it, some rules provide for it. It depends on the rule. That's why it's best specifically prescribed. Otherwise it's going to be a...
I think Mr. Rajah has something to say on that.
I'd like to address the question the young lady asked earlier, which I think two of my fellow panelists answered. Actually, let me reframe the question. I think what you want to know is why would, or in what circumstances, would a party seek relief for domestic arbitration when ready relief is already available? Why would they want to go through hoops and take the risk of getting an emergency arbitrations order which might not be recognized? The obvious and most expedient method would have been to apply under Section 9. Have I framed your question correctly? I see from your nod that I've got that. Okay. It's a matter also of commercial judgment. And here I'm speculating because I don't ask parties why they seek appointment of emergency arbitrator. The obvious answer would be to follow the letter of the contract because this was the bargain they made. There may also be concern about the certainty or consistency of the judgments at the High Court level. And there have been a wide variety of views expressed in India up to then and even now today in relation to foreign-seated arbitrations. Let me just pause here and digress. And I speak as a friend of India, and I'm sure you will accept that any criticism, and I do this often in Singapore as well, of existing positions or attitudes is set in good faith. If India wants to be taken seriously as an international arbitration center hub country, the judiciary, the legislature, the legal community have to work in tandem. And I think there's really no good reason, and certainly there's been no public reason given, as to why Parliament did not accept the recommendations of the Law Commission report and then a very well thought out recommendations of the Sri Krishna report. Now maybe they thought that this is lawyer's law and we don't want to get involved with this, but then they made certain very technical amendments to other provisions. And I would strongly urge all of you, because it's the unanimous view of everyone here, a foreigner and 3 eminent Indian jurists, that the law should be amended and updated. And it's for all of you in the arbitral community, because everyone from the Prime Minister to the Minister of the Law to the Chief Justice to many of the chief ministers in different states say they want to make India more arbitration friendly. And let me tell you, being arbitration friendly means making your laws more predictable, more consistent, and transparent. And enormous progress has been made in the last 20 years. And I must give credit in particular to Chief Justice Kapadia in his Vendetta decision. And that, I think, turned the tide post-Malcolm. And the Supreme Court has been consistently giving decisions which are applauded by the international community. But I think your parliament has to do more. You look at the speed with which the parliaments in the other arbitration hubs react and respond. They don't take decades. They take a couple of years. And these are amendments that doesn't affect the man in the street. This is not going to change the price of onions and lentils and cause riots. And I say this because I used to be in public office as Attorney General as well. And I frankly can see no good reason why the recommendations of some of the most eminent jurists in Indian arbitration, including Indra Mahatral, Sri Krishna, Justice Ravindran, were not accepted. And I think all of you here today, if you want to take a message from DAW, if you want to take a message from this session, speak to your parliamentarians, speak to your politicians and tell them, look, we have to work together, we have to update our laws. That's my first observation. My second observation is this. I notice the term used often here, ADR, is referred to as alternative dispute resolution. Let me update you. The appropriate term is appropriate dispute resolution. Because if you think about it, historically, the courts solved all sorts of problems. But when we look at commercial problems today, the complexity, the time they take, the legal community and the judiciary have come around to the view, and I can say this because I used to be a jurist or a judge. It is not the best use of public resources and judicial time to spend 3 weeks, 1 month, 2 months hearing complex disputes between two private parties. So the Singapore solution for this was, all right, other than criminal, family, and tort cases, if you take up more than 2 days of the court time in solving private commercial problems, you pay for it. So that you have to pay substantial court fees for anything in excess of 2 days to solve private commercial problems. Your free time is 2 days. Now, I know that may not go down well in India for a variety of reasons, but the point I'm trying to make is appropriate dispute resolution means that we need to pragmatically address the resolution of complex commercial problems. And that's where a real partnership must occur and must take place between Parliament, the judiciary, and the arbitral community. And you need to create an umbrella body to discuss these issues and see how best to solve it. Now, who's going to take the initiative to create this body? Now, I looked with interest the Arbitration Council of India, but that doesn't exist. That was proposed quite some time ago. You've created now, and I just met Justice Herman Gupta to exchange views on the India International Arbitration Center. But I also think you need, over and above that, a central decision-making collegiate group of stakeholders to continuously update and implement Indian arbitration laws. If you don't get that right, you will not be as competitive as the other established jurisdictions. So that's my advice as a friend.
Radhika, our compere, has an interesting take. She has passed a slip. From a practitioner's point of view, she says, ex parte relief chances are better with an emergency arbitration.
No, that's wrong. Okay, let me address you. We look at the statistics.
And she has one more input. She says that we should only think of the metropolis because sometimes the original jurisdiction lies in across the country, and distance, logistics, and expertise on the subject could all go into the decision-making process.
Okay, the latest trends, and I try to keep up to date, statistically, I understand that only 40% of EA applications globally succeed. The majority of them fail. So that's not the reason why people go to emergency arbitrators, and most emergency arbitrators, and I usually try to stay away from being an emergency arbitrator, except in the rarest and most interesting cases, because it's hard work, short time, and definitely the subject of much dissection at a later point of time. But through hard cases, sometimes good experiences come. And I think while this has been a painful experience for many involved, including my colleague here, who I only found out just before the session was on the opposing side of the, he was acting for future, am I correct? Yeah. And it's a lesson, I think, that we have all learned through the process and made more apparent the gaps in the law. So the heartfelt views that I expressed just now, that you need to work collectively. You know why Singapore has been so successful? First, we are small. Second, we're smaller than Delhi, certainly in terms of population and our belief in size. But the only reason Singapore exists, leave aside Hong Kong exists because of China as well, but the only reason Singapore exists is because of our efficiency, our productivity. And our favorite mantra is, borrowed from Andy Grove from Intel, is only the paranoid survive. Because if we don't keep improving, if we don't keep being updated, we will cease to be relevant. And that's the kind of DNA you need to have to be a thriving arbitral center. You need to keep up to date. So I reiterate again, and I don't think any of my panelists here will disagree, that it should not be up to courts to solve the gray area, because it will just engender more time, uncertainty, and make India less attractive as a place to do arbitration. You have got all the ingredients, especially the quality of the talent and the people. McKinsey calls this the population dividend. But it's not just that. I mean, Indians have succeeded in every area that they've gone into, finance, technology, and there's no reason why India can't be, within the next decade, and many of you sitting in this room, be global thought leaders in arbitration. But you need change, yes.
Please pass on the mic.
We have exceeded our welcome.
We have Radhika. We've exceeded our time. But
We'll take 2 more questions and then we will end the session.
I have a small question. I'm a general manager from public sector undertaking. This emergency arbitration is really gives a speedy remedy, but there are some institutions where, like LCIA, which gives a clear bar on emergency arbitration as far as the contracts which are prior to 2014. So my question is there any other provision similar to Section 9 here in gives any inherent power to them apart from emergency arbitration in other countries?
there is Section 9. No, but there is a parallel scope anyways. What is this? No, I don't think there is. What is your answer?
Why would Section 9 be barred?
Yes. 9
Oh, you mean LCA rules?
Oh, okay. We were thinking of the section.
That's not within our province.
Yes, that perhaps would be a matter of discussion specifically relating to that rule and not overall. We were mixing it up with Section 9 of the Act, and that is why I'm a little confused.
So your
Why would they
question.
not take
Yes.
up? They have a Article 9. I have the LCA rules with me. And if the dispute has now arisen, why wouldn't there? Was
Pass
your
it
case a
forward.
pre-2014 case and they?
What is the
Prior to 14.
significance
That's an
No,
individual.
contract may be prior, but I see. Oh, I see.
Because they introduced it only in
That's the rule
2014.
because of Balco.
Then you're
That's true.
restricted them to amend it.
One more question, please.
Mr. Gupta, please go ahead.
Amit, your mic is perhaps not on.
Audible now?
Yeah.
I'm Amit Gupta from Delhi. So my question is to Mr. Rajah specifically. So we discussed Section 9 and EA. Section 9, as I see it, I don't need to invoke arbitration. I can go to the court, get an ex parte order. Maybe an ex parte order from a court would have a higher pedestal than an ex parte from an EA. So do you advise making amendments to Section 9 per se, so that even for the domestic arbitration, there's a trend towards EA?
No, I think you still have to give, I say this without the deep experience my colleagues have of the Arbitration and Conciliation Act, but I would say that you should not make it exclusive. You should always give the parties the choice. That's the whole essence of arbitration, autonomy. So you leave it to the parties to have the choice. Give them the legislative remedy, but if they choose to go by way of arbitration, let me give you an example. You might have international arbitration, let's assume even if you get your act amended, they may still go for the EA because the assets of the defendant may be in several different jurisdictions, and you might not want to go to several different courts. You might want to have just one order and then pick and choose how you're going to enforce it. But I think the clarity that legislative amendments can bring to make this option available will first mitigate the need to go for litigation and reduce litigation, because Justice Nariman very rightly said that the courts are trying to unclog their arteries because there's just too much litigation. But this is where Parliament comes in. The Parliament should give new arteries, not just unclog the arteries, to allow business people, because at the end of the day, we have to look at not what the lawyers want. We have to look at what is good for the common good. And obviously, solving problems faster will benefit businesses, and that in turn will percolate down to the general population. And that's the way we should look at things, rather than look at what is best just for the legal community. And the more opacity there is, as you pointed out rightly, the more litigation that's going to be generated. And the only people that benefit are not the best lawyers, who really don't need this sort of work, but at the end of the day, some of us who are practicing in the gray areas, which in this particular landscape, arbitral landscape, can be avoided.
And it could be easily done, because the recommendations of the Law Commission was specific, that you include emergency arbitral awards also in the definition of arbitral awards for the purpose of Section 17. You could have done just two things: carry out that amendment in Section 2, and also when you amended Section Part 1, make Sections 9, 17, 27 and 37 applicable to foreign seated arbitration. That would have solved the problem.
Can I make just one more comment?
I think you're running against time.
One last comment. So I conclude by saying, high marks for the judiciary, just a pass rate for the legislation.
Thank you so much, Honorable Chair and the other panelists, for such an engaging session. And sir, we've taken note of your suggestion, and we have the Honorable Law Minister coming tomorrow. We will take it up with him. Thank you.
You can give a transcript.
Will do. So now we'll take a short break of 10 minutes and resume at 4.
Nice to meet you. And please go ahead and get in touch with me. Nice. Well, I think you made a number of good points. So thank you very much. Thank you. Not at all.
I thought we were going to say thank you for going.
That too.
Very nice.
Very nice. And thank you. And we'll be in touch. Thank you. So, if you're ever in Singapore, can I give you my email?
Okay, gentlemen, there's a photo session, so let's just
Yep. Yeah. Just trying to pack all this.